may be doing for Honorable Justice of the Appeals Court, and I said in Washington, Commonwealth, draw near, give your attendance, you shall be heard. I said the Commonwealth of Massachusetts, court is now open. Please be seated.
Good afternoon, everybody. Thank you for coming in. This is a sitting of the Appeals Court on Wednesday, February 12th. I'm John Englander. This is your panel for the sitting. To my right is Justice Hodgens. To my left is Justice Smyth. I know some of you are familiar with the rules of the court, but just so we all, they're 15 minutes aside, there's no rebuttal.
I know enough to stand up for the judges. Okay.
Oh, no, that's fine. You don't need to. Actually, you don't need to. There will be no rebuttal, and I encourage you to get right to the point. We've read the materials. We will certainly have some questions. The case is 24P 491, Mr. BRAGINTON-SMITH versus Ms. TEREN, and Mr. Alva, you are representing Mr. BRAGINTON-SMITH.
Yes, sir.
The floor is yours.
Well, as your honors have reviewed the material, I'll focus on the latest item for our appeal, and I thank the court for giving me leeway to go ahead and file what effectively amounts to an amended appeal following our discovery of a new witness. And I'm going to focus in appreciation of what Your Honor Englander has stated, that the just response to some of my sister counsel's points here that she raised. She attacked, we had in this case a new witness, a Mr. John Francis English, who my client ran across, who had actually relevant testimony, and that being just on the issue of a non-family member's recollection of the discussion between the decedent seller of the property, the real estate agent, and the decedent, my client's mother, who was very, very central to the case. And sister counsel in her opposition stated that our affidavits, perhaps for the purposes of even a strategic reason in support of our motion to the Honorable Judge Gilday, we didn't give any specific dates and the like about when this new witness was discovered, and there was some vagueness about that. She basically has accused us of being deliberately vague in that issue. And I would point out to the court some factual items, some procedurally factual items that my client came to me when the 12-month period was nearly over for any type of opportunity under Rule 60.
Is this all in the record, counsel? That your client came to you, what you're about to say? Because if it's not in the record, it's not before us.
My client's affidavit states that the answer to your question, I think, would be yes, Your Honor.
Very good.
Okay, it would be, because it actually states there in his affidavit that he arranged for him to come to my office on Friday, October 24th, 2024, which was the appeal period, I think, was up in mid-December of 2024. So that was on exhibit number A that was given to Judge Gilday. So he did indicate there. My client's affidavit is actually dated. This is also on the record for 10/28, 2024. Mr. English came to my office a few days before that, and then I prepared the material.
Let's cut to the merits, though. How would it not be cumulative? You reference again, it wouldn't be the plaintiff, or wouldn't be the plaintiff's wife or girlfriend, partner, but it would be cumulative of their testimony, even though it's not a family member. So how would it?
I had two family members, and if you reject the proposition that a non-family member is not cumulative, then I lose. First, we only had two witnesses on that. The jury could conclude this is self-serving testimony, husband and wife. We had no one else, no third parties, because they had deceased, who have no, I hate to use the phrase, but it's no skin in the game. And my client finds Mr. English here. And so that is why I believe it is not cumulative. He could have been asked to testify.
How does
at
it
trial.
help you? What is it about what Mr. English has to say that helps your case?
That he was present during the time, as indicated in his affidavit, Your Honor, that he was present at the time when the decedent, my client's mother was present, and others were present, but his father, Mr. English's father, and they were looking at the property at the time that the cleanup was being conducted. And she basically, it's an admission by the decedent that with perfectly admissible testimony and the circumstances, that she understood that this property was to be for her son.
That's not what it says. I heard Mrs. Smith state that she would need to have to put the house in her name, so Brian's ex-wife couldn't take it. That's what you said, right?
That's right. That's what he heard.
And we're to say, oh, that means I'm giving the house to my son?
I see where you're indicating the gap. I had anticipated that Judge Gilday would give us an opportunity to have a hearing on it so that Mr. English could be questioned on that specific issue. When I interviewed him to get all the different facts, I did not want to put any words in his mouth, and I didn't want to extrapolate too far to try and lead him on in any of that.
But it's your burden to show that this is sufficient, that this is significant enough that we need to reopen a judgment, right?
Yes.
I have another question. It says that this happened in the year 1994.
Correct.
In the year 1994, as I understand the facts, your client had the house under agreement, not Mrs. Smith. Mrs. Smith didn't buy it for 2 years.
That's right.
So what do we do with that? Looks like it's an issue. It looks like that's an issue because it doesn't make sense.
Yeah. It could be, but again, given the passage of almost 30 years between the dates, Your Honor, people...
But he identifies it to a time period that makes sense. They did the cleanup in 94 before your client went into the house, right?
No, actually, my client was there in the house. My client had moved into the house, and it was under agreement, but the purchase did not take place until 1996. I think those are facts. I don't think there's any dispute about that. That's established on the record, Your Honor.
Well, it is identified to a particular occurrence when the house was lifted and oil was being removed.
Yeah, that's correct, during the cleanup process. And I would say at the very least, there's the inference here, why the question...
Is there evidence in the record that tells us when that happened? That's an event that you could probably identify even 30 years later when it occurred.
Which factual item are you referring to?
The house being lifted so that the oil could be removed from beneath the house. Was that in 1994 or later?
I think that's actually in the transcript. I'd have to look up the actual, I can look up the transcript really quick here on that to see if they actually used the word lifted during the trial or cleanup. Cleanup is mentioned many places in the record. On the trial transcript, page 92, during questioning, there was discussion about the cleanup at the property before then.
I don't mean to throw off your argument. We can look at the transcript ourselves and try to figure that out.
Okay. All right. But I would say at the very least, in response to Justice Smith's question, and yours too, Your Honor, Englander, at the very least, there's the inference there. Why, in Mr. English's affidavit, why would my client's mother want to shield the property so it could be taken by his wife, his ex-wife, as part of... So I think that logically leads to another, which is probably why I did not insist that Mr. Englander be specific. Plus, he's recalling to me what he had heard. I want to hear what he heard, and that's what's going to be put in the affidavit.
So let's assume that you have enough to establish an inference that at some point, at some time, maybe 1994, Mrs. BRAGINTON-SMITH had the intent to purchase the home so that it could be ultimately the property of your client. Why does that matter why does that significantly help you with respect to a constructive trust kind of theory when it seems to me the evidence, it doesn't appear to be disputed by you that the deal was that your client was to pay the mortgage, taxes, and insurance, and he failed to do it. And it was only after he failed to do it that Mrs. Braginton-Smith then sold the property or gave the property to someone else.
Yeah. There's no dispute, Your Honor, that my client, that payments were made. The testimony at trial.
No, that's not the question.
Okay.
There doesn't appear to be any dispute that payments weren't made and that the house was in foreclosure on multiple occasions. Yes or no?
Yes. Yeah. And what I meant when I said that payments were made by my clients, and that a final payment on the last mortgage was made by Mr. Braginton-Smith's mother. The answer to the question was ambiguous. Are you telling me that if we read this record, we're going to conclude that your client made all the payments that were expected of him? When you read the record, you're going to find, no, that my client did not make all the payments that were expected of him.
So if that's true, then where is the basis for a constructive trust many years later?
On the record, Your Honor, my client did not know that his mother was going to make the final mortgage payment, and it's speculating afterwards, but it's not on the record, so I won't go there. That's number one. Number two, for the claim for quantum merit and unjust enrichment, which are also part of our complaint, there is no dispute that my client paid the vast majority of all of the costs associated with the property for all of those decades, above and beyond what he would have been required to pay for any type of rent or for use and occupancy of the property, that he purchased.
That proved?
Excuse me?
The last thing that you said, above and beyond what he would have been expected to pay for rent, was that proved?
In the penumbra, there was never any question about rent while he was there. So the answer to your question there, was that proved on that specific point, which I just said, no, it was not. But it was not raised as an issue of fact during the trial. The defendants were seeking use and occupancy for the time afterwards. During the.
But you represent to the court, case went to trial. You represent to us that he made payments that were above and beyond what he would have paid if he was just a renter.
Mm-hmm.
And all I was asking was that proven?
No, it was not. It was not. But again, going back to my original point on that, Your Honor, for the quantum merit and the unjust enrichment aspect of it, on record, the facts were presented to the court that but for my client's work to negotiate a price for the property based upon the cleanup, it could never have been acquired at that price, which was a lower price, and that over the years that my client made payments for taxes, for insurance, for maintenance on the property, and mortgage payments as well. So all of that, the trust, my client's mother, they benefited from all of that. And so that is also part of our claim as well. We have the equitable claim for title, but we also have these other claims as well. So strategically, when we were addressing, why was the last final payment made, it's just speculation. This is not actually part of the record. We thought, well, maybe that was done as a way to in anticipation of a problem when my client's mother died and the like. But that's just a speculation on our part, because my client didn't know any knowledge that it was going to be done. And as indicated in the facts presented in the case, and in our brief, original brief, my client was shocked when he gets a notice to quit.
The house in foreclosure when the amount was paid?
No, I do not believe it was. Factually, no, it was not. I don't believe so. But so he was caught by surprise because he didn't ask to see the actual trust documents. You had the attorney Dupuis, who had testified as to his meetings with Ms. Braginton-Smith, my client's mother, before how the trust had been established, the MR trust, and that my client testified that he had many conversations with his mother over the years, and there had never had any indication whatsoever that this property was in any way not going to be deeded over to him, and that he would not have had the opportunity to make any final payments that she would have asked for. So I think that does address part of your concern, Judge Englander, about the, factually, he didn't make all the payments, because factually, the final mortgage, there was some money that was paid, a good chunk of change. I think it was about $60,000 to pay off the final mortgage, but that my client was never given a fair opportunity to do that in relation to the agreement that my client alleged in the complaint, in which Mr. Englander would be testifying to about the original intent of the parties.
English. It is confusing.
I'm sorry. That's
I'm Englander. He's English.
Forgive me, Mr. English.
Sorry. I've seen mistakes like that before.
Other items, I only have a few seconds left, but I do believe that that this was a case. I think the most important point that I raised in my initial brief was just Judge Gilday. Judge Gilday is not a judge who browbeats anyone. I'll say that. He tries to move the case along, but it became clear to me that the main problem that we had was his summarization of my client's testimony, and I highlighted that part in our first brief where you can see that. My client's trying to answer the question, and at the end, the judge says, so the answer is no. I think that these circumstances really prejudiced my client, and I appreciate that.
Because you think it sent a message to the jury?
Correct. That's correct. So they were
Now, there was a shorter way to answer the question?
Well, there could have been, but my client's trying to answer the question. Attorney Lundy was basically indicating that that on that particular issue, the judge has the right to make sure the trial goes in accordance with its flow, to prevent cumulative evidence and testimony. But these were really important times when my client's trying to testify about what work he had done to preserve the value of the property, to maximize, to reduce the cost and the like, to address the issue.
But it was an easy question. Did he purchase the property? And he said, I couldn't purchase a property. The judge said the answer is no, essentially, correct?
Yeah, that was part of it, yes. That's
so how was that really prejudicial? I mean, first there was no objection to the judge's insertion of his, or moving the trial along, correct?
That's right. At that time, I did not object.
And how was what your client said different than the answer is no?
Yeah. First, on the issue of no objection, I would think on that exact same section, the judge says immediately, next question. That was one of those times when he says, just moving along with the next question. So, but I'm sorry, could you
Yes, just briefly. I don't mean to belabor it, but how was really what the judge summarized different from what your client was testifying?
Well, I think it was done in such a way, when you read the testimony, that the judge may have stepped over the line as far as providing testimony to the jury. And Attorney Lundy had pointed out, well, you have your jury instructions that would have corrected any of that. But the standard form jury instruction is that the jury is not to take any of the statement of the judges to any of the counsel, whether by way of sustaining objections or overruling objections, is to take that as any evidence one way or the other of which way that the court is going. And so that type of instruction was not given that was given in this case, but in regards to, summarizing a witness's testimony, especially material witness such as Mr. Bragington-SMITH, there's no instruction that would take care of that. So I think that the jury could reasonably conclude that the judge's stopping my client from testifying or trying to summarize this testimony in one or two words, something that took several paragraphs, I think that can prejudice the jury, and I think in this case it did.
We're going to leave it there. Thank you very much. You're over time.
Thank you for consideration, Your Honors.
We'll hear from Ms. Lundy.
Thank you, and good afternoon, Your Honors. May it please the Court, Sandra Lundy for Dorothy TEREN. I can't help but start out with the 60B2 argument that my brother started out with, and to notice on the trial transcript, page 116, the first thing he said to the jury in his closing argument is, who can remember what happened last year, let alone 26 years ago? So, I mean, you know, talking about the credibility of the of a statement that somebody said they remembered hearing from somebody else over 26 years ago.
But she is, as your brother points out, she's the disinterested, he is the disinterested witness in this.
Well, he is, but his testimony is unconsequential. Remember, this is, and let's start with the unconsequential nature of the testimony, and then I'll get to whether he could have been found or not earlier. This is an event that happened, as Your Honor said, in 1994. Well, in 1994, there was an active agreement to have him try to purchase the property. And so let's say we agree that his mother said at that point, you know, I'll try to help him out. But the record shows that he wasn't able to purchase the property. And then she stepped in 1996 and she purchased it. She purchased it on her own. He didn't insist on seeing documents. The documents were right in the record. It's whatever she may or may not have said in 30 years ago in 1994 had nothing to do with her actions in 1996.
Oh, that's helpful. That's
You know,
a good point. If it is 1994, and we don't know, because this is a pretty spare affidavit, but the statements would appear to be about the purchase and sale agreement with Mr. Braginton-SMITH that was never consummated, right?
That's the only specific date that we have in this affidavit, except for when people met with the lawyers.
Can you answer my question that I asked your brother? Do we have a date on when the house was lifted and the oil was removed from underneath the house?
We have that in the English affidavit because he says he was talking to Dorothy.
Well, no, but let's leave aside the English affidavit because who can remember
Okay.
what happened 26 or 30 years ago? Do we have other evidence in the record that tells us when that happened?
We do have evidence that, I don't think we have a specific time frame. I don't see a specific time frame. I know that it was...
Was it before Mr. Braginton-SMITH moved in? It's hard to be in there if they've got the house lifted up.
That's actually when I was reading the transcript, I was thinking, who wants to stay in that house with, you know, that's got oil in it? So my sense was that that was not in the record. But certainly, I think by 1996, it seemed like everything was remediated. But again, I don't find it specifically in the record. There's no timeline. There were no documents submitted.
The case?
I did not try the case. No. There were no documents submitted about the work that was done. There was just testimony. So I'm sorry, I don't have more specific. I mean, he just says that in 1994, he was watching the remediation happen when he came upon this conversation between his father and his close neighbor. And I guess that brings me to the second point. You've got somebody who has been your neighbor for decades. They know the family, they're friends of the family. They've watched the remediation of the oil, and all of a sudden, he just appears as a witness. He couldn't have been questioned. I mean, I'm looking at the Carroll versus National Court case, which is a Justice Abrams decision, where she says, when you're talking about, you know, newly discovered evidence, quote, garden variety omissions are not enough to get you over, you know, to get you to a new trial. And this, if anything, at most, it's a garden variety admission because he's a person that, if you were searching for witnesses, he was alive, he was there, he's friends with your family, he still has a house there. Why wouldn't you talk to him? So I don't want to belabor all of the 60B issues that I have in my brief, but basically there was no explanation for why he wasn't discovered sooner. It's not likely to alter the outcome. You know, the case, the Van Alwen case, that was when somebody had epilepsy and as a result of an accident, but the epilepsy didn't manifest for years after the accident. And the court said, well, you know, you can get a new trial because there's a different sense level of damages. This is not that. This is very much not that. So,
Is Mr. Braginton-Smith still on the property?
excuse me?
Is he still in the property?
Yes, and he hasn't paid rent since, or mortgage, since I believe it's, since his mother paid off the mortgage, 2016.
Isn't there an order for use and occupancy?
What I understand is that the housing court proceedings were stayed because of this appeal. So
You didn't handle that. There's a summary process case?
that's my understanding, yes, yes. So that's what I read in the record. So basically, you know, I mean, essentially, the argument about the judge doing
When did
things.
judgment enter?
The judgment entered in 23. The trial, the complaint was filed in 2020. I assume there are some COVID delays, and the case was heard in 2023.
And then who instituted the summary process case, since you didn't do it? Who did it? Another counsel instituted the summary process action?
Your Honor, I can find out for you, but I don't have that information.
And so you don't know when that was initiated?
No, could I submit a?
No, that's all right.
Okay.
If it's outside the record, it's outside the record. I have a memory of it because of the motion practice when your brother submitted the new trial motion and asked to appeal that. Okay.
So basically, I just wanted to go over a little bit of what was in my brother's main brief. Essentially, his argument boils down to disagreeing with the credibility determinations of the jury. And he couches it in, well, the judge made mistakes. When we look at the record, all of the jury did three things that juries always do, right? They listened to the judge's instructions, and there was no argument between counsel about the judge's instructions. They looked at the 45 documents. All of the documents were submitted jointly, so they come in for the substance and the admissibility. And then what's left? What's left is trying to decide between two competing arguments. Now, it took the jury, having sat 2 days, looked at 45 documents, and listened to 6 witnesses, it took them exactly 1 hour to come to their conclusion. And I would submit to you that that was because the documentary evidence aligns very neatly with the testamentary evidence of the defense witnesses. I mean, just it lines up. Mr. Braginton-Smith's 2 witnesses contradict all of the documentary record except for the purchase and sale agreement that was never consummated in 1994 that he didn't put in the record on appeal. If we look at his argument that the judge was allowed highly prejudicial testimony about the fact that Ms. Braginton-Smith, Dorothy Braginton-Smith, gave Mr. Braginton.
Mother gave my brother large sums of money at several different times. That's material in this case, right?
Yes, because remember on transcript page 131, transcript 1, volume 1, Brian testifies, my mother was the one that was guilty of lying to me, all right? And then he repeats that on page 163, she's a liar. So obviously, the defense has a right to put on testimony that contradicts the image that Mr. Braginton-Smith is trying to portray of this woman as deceptive, lying, conniving, etc. And also, it explains the provisions of the will, which otherwise look like she's deceptive and conniving and untruthful and otherwise, and she has some grudge against Brian. So it was directly relevant to
Well,
that.
but is it admissible evidence? Mother gave my brother large sums of money because she would call me and tell me. Isn't that hearsay?
It wasn't objected to.
I think it was objected to. I'm
I-
pretty sure. I think I just read it this morning, but
Yeah,
I'll look at it
I'm
again.
sorry. What Ms., I think it's Diana, basically said is, I did the bills. I know.
Well, no,
what
that's
was
not
done.
what she said there. She didn't say, I know because I did the bills. She said, I know because she called me up and tell me. That's all in the same sentence.
But the fact that he was given money is not the, I don't think that is disputed.
What other proof was there that he was given money by his mother?
Both sisters testified to that. And then Mr. Dupree, who was the attorney for the estate, said she structured her estate this way because she'd already given him money. So there was plenty of evidence that she gave him money. So even if it was an error, it certainly wasn't an error that was harmful to the extent that it would negate the jury's verdict.
Does the mother's statements, she'd passed, right?
Yes.
So do her statements come in under that provision, the hearsay exception that we have in Massachusetts for statements made in good faith by a person who's now deceased?
804, that would be 804, I'm sorry, 5, I'm sorry, yeah, 5A, yes. That would come in, but there wasn't, and one of the other things that's, I think, remarkable in this trial is how few objections there were to hearsay
Oh,
testimony.
there was an objection. I'm sorry.
Yeah, there wasn't.
You objected to the question. The question was, are you aware whether your mother would have given any financial benefit to your brother Brian prior to him taking possession? Objection. Overruled. So it's objected to. And the answer then is, I'm aware my mother gave my brother large sums of money at several different times throughout the time that I was living in different places because she would call me on the phone and talk to me about it. I mean,
But there was no motion to strike that section.
you're correct. There was no motion to strike.
Yeah. So, I mean, so it
And it's
counts
not
in.
necessarily responsive.
Right, right. And I know that one of the issues in the appeal is that the judge hurried along the testimony and he objected too much to Mr. Bragington-Smith's testimony. But if you look at the objection, Mr. Bragington-Smith keeps trying to push testimony about what Mr. Dunphy, the owner of the property, said. There was no, first of all, it's irrelevant, and second of all, it's hearsay, but it's irrelevant because there was no, it's a side issue. There was no question that the property needed serious remediation. That was never an issue. For some reason, Mr. Bragington-Smith wanted to go into a long discursive response to a very simple yes or no questions about how much he did to fix this horrible property. But there was never any question about that. There was never any question about that. The fact that the property was a bargain, there was never any question about that. I mean, this is a jury of people who live on the Cape. I mean, they know that a property for $140,000 near the beach, I mean, they could use their common sense and know that this property was undervalued. But it wasn't, and it's not an issue in the case. It's a bragging point, but it's not an issue.
Well, no, I mean, he's saying a reason that the jury can infer that this property was always intended to be mine is because of what I put into that property. That's the argument, isn't it?
The record shows he put nothing into the property except to identify a problem and get the insurance company of the owner involved. There's no, he didn't put out any money to do the remediation.
But he lowered the cost. He lowered the price. That's the argument. I'm not saying I agree with it or I don't. I just think that's what the argument is. Your time has expired unless my folks, I think we understand it. I think we have the argument. So thank you very much.
Thank you, Your Honors.
Thank you. Court officers and clerks, thanks a lot, folks.